Good morning, everyone. My name is Rachel and I'll be your moderator. Today's webinar is sponsored by NatRoad's Platinum Partner Packer. Whether it's moving freight across the nation or going the last mile, their DAF trucks are always delivering. So now let me introduce our guest speaker, Gillian Bristow, Legal Practitioner Director at Bristow Legal. In this webinar, Gillian will take you through all the tips and traps of the debt recovery process in this 30-minute webinar. Like always, we'd love to hear from you during today's presentation. So if you do have a question for Gillian, please feel free to type your questions into the Q&A section at the bottom of your screen. You may send in your questions at any time during the presentation, and we'll be answering them at the end of the session. So without any further ado, I'd like to kick things off by welcoming Gillian. Over to you.
Thanks so much, Rachel. It's really lovely to be here, and by Brisbane standards, today's cold. I'm wearing a jumper and a jacket, but I'm pretty confident that I'm a lot warmer than Rachel is in Canberra. The topic of our discussion today, actually, Rachel, can you pass me control of the slides? Because I can't move onto the next one. Aha, so onto the next one. So the purpose of our discussion today is to talk about debt collection. Debt collection is one of those things that's part of every business. And in my experience as a lawyer, very often the reason that businesses fail is not that they don't work well, not that they don't do a really good job of marketing their services, but simply because they don't get paid. At the end of the day, if you don't get paid, there's no money in the bank, you can't pay your staff, you can't pay the ATO, you can't pay your contractors, and business grinds to a halt. I think too, it's particularly important in transport because we are talking about low margin work. So a lot of the time you're doing work where you're lucky to make 5, 8, 10 cents in the dollar. So if you lose, for example, a debt of $10,000 that you can't recover, you've basically got to go and find another $100,000 worth of work for the year to be able to make back that amount. So when you are thinking about debt collection, there's two things to ask yourself. When you're effectively giving people credit, how much can I comfortably give this person, and how comfortable am I that I will be able to recover it? So that's the first question that you always got to have in the back of your mind. And the second question is, how good a customer is this? Is their work important to me? Would I lend them this money if I was a bank? And that's my activity, and my business activity was actually the business of lending money, because that is what you are doing when you offer credit to customers. Now, the context of this webinar today is that NatRoad a few months ago issued a guide to debt collection, and if that's freely available to members, and it goes through a 4-step process as to how to go about recovering debts where you've got a problem. And there's also a really good example letter of demand in that guide itself, which can be useful when you get to the point of needing to recover a bad or a doubtful debt. So today we're going to be talking about the various steps that are outlined in the guide. And then we're also going to be, as I say, going through some questions, etc. Now I'm just pressing buttons again here, Rachel, without any success at getting the slide to move along. Oh, I think it's just delayed, and that's what's happening. So before we get started, the point of the NatRoad guide is very much what to do when you have got a bad or doubtful debt. But the ideal is that you never ever need that guide, because everybody pays you on time. So my very first little discussion as part of this webinar is things that you do so that you never have to call NatRoad to ask for the guide. So avoiding issues with your debts in the first place. So there are some basics that everyone should do when they're offering credit to customers. In my opinion, it's really important to have an actual credit application form. Now, on that credit application form, you collect details like, who is your customer? There have been plenty of occasions during my years of practice where a client will come to me and say, XYZ owes me money. And then I'll go to do a search and I'll discover that XYZ doesn't exist. They aren't a registered business name. The ABN that I've been given, for example, is deregistered or isn't in use, or what's on the customer's order forms is different to who's paying the bills. So the most important thing to get straight from the beginning is who exactly is your customer. So from that point of view, you need to know what their ACN number, what their ABN number is, who's actually running this business. And you also need to check that those numbers are correct. Because like I say, there's not much point having to go and institute legal proceedings against a body that you either can't find or doesn't exist. Credit application forms are also useful because they do things like, for example, set payment terms. And within those credit terms that you have attached to your credit application, you can also have clauses that, for example, say, as soon as your payments are overdue, we can accelerate all of them so that you owe us all of that money. Because otherwise, for example, if you've got a customer who's got some money in 60 days and then a whole bunch in current, and you want to issue them a demand for the whole lot, you can't do that until the bit that's in current is actually overdue. But if you've got a term in your credit application form that lets you, then that's different. The third point is much along the lines of what I was saying earlier. Think about yourself as a banker. Decide how much credit would be appropriate. If you were a banker, if you went to a bank and asked for a loan of $40,000, would they give it to you without security? If a bank wouldn't do it without security, then you should think very carefully about whether you're prepared to lend that particular customer that much money as an unsecured debt. Now, there are a few other things you can think about to protect yourself. One is getting a director's guarantee. So a director's guarantee is where your customer is a company, but you have the directors of that company personally say that if the company can't pay, that they will basically step into the shoes of the company and pay the amount. Not every customer will sign it, but if someone does want a lot of money on credit from you, then it does give you a little bit of extra security if they don't pay. The other useful device that can work sometimes in a debt collection scenario is a lien. So a lien is where you're entitled to hang on to something until you get paid. If your transport conditions, your conditions of carriage, have got a contractual lien in there, there are some circumstances in which you might be able to hang on to freight that's in your possession until such time as you've been paid. It's a really complicated area and I could talk for a full hour on this, but just always be aware if you're in one of those dispute situations and you happen to have customer property, that you might be able to basically hang on to it until you're paid. If you are actually storing goods, so you're operating a warehouse and a customer hasn't paid, then there are also various pieces of state legislation in every state other than Tasmania that give you as a warehouse operator the right to hang on to goods until you've been paid for their storage. So bear that one in the back of your mind as well, because with a lien, once you've parted with possession of those goods, that's the end of it. So it's too late to think about whether you might have had one after you've already given the goods back. So that's the end of the points about trying not to get yourself into a position where you've got an unpaid debt. But if we then move on to assuming that you've got a problem, we're now going to talk about the sorts of steps you would go through to try and get paid. So phase one is essentially work out what the lay of the land is, work out what your issue is and what you're going to do next. So this sounds a bit obvious, but the first thing you need to do is work out whether you actually have a provable debt. So the first point on this slide is a bit along the lines of what I was saying with respect to the credit application form. Work out who exactly owes you the money. What's their name, their address, their legal status, are they a company, are they a partnership, what's their ABN? Because you're not going to get very far unless you know exactly who it is that you're going to demand pays this money. The second point is, do you have all your documentation? If, for example, you transported goods from A to B? Do you have proof that they asked you to do that? Do you have proof that the goods were actually delivered at the other end and there was no problem with it? Do you have proof that they asked you to transport it from A to B? So do you have an order form or an email requesting you to provide the services? Secondly, did you invoice the customer and can you prove it? Have you got a written invoice? Can you establish that you sent it to them, whether it was by email or whatever, and that you sent it to the right address? Thirdly, what were the credit terms you agreed to? And again, this harks back to my, do you have a credit application form? Did you agree that it was going to be cash on delivery? Did you agree that it was going to be 30 days from the date of the invoice or 30 days from the end of the month? Because unless you know that, you can't answer the next question, which is the payment late according to your agreed terms? And then it's important to work out, is this an undisputed debt? Is there a problem with it? What have you done so far to try and get paid? Have you issued reminder notices? Has somebody called? Has anyone disputed this debt? And if so, on what basis? So this is really your planning phase. This is getting clear in your own mind what the current scenario is. So let's assume you're able to answer all of these questions and you're confident that in fact you know exactly how much you're owed and by whom and the circumstances that would back up your claim that the money is owed. We then move on to phase 2. This is where you decide what you're going to do about this based on a number of factors that we're going to go through. Again, the first dot point in this slide sounds kind of obvious. Decide whether it's worthwhile to act to recover the debt. Now, for example, if the debt's disputed, it's a really small amount of money, it's going to cost you more to recover that debt because it's disputed than the amount that is actually owed, then you might actually decide it is not worthwhile. Another issue is you want to make sure, if it's a company, that you actually can recover the debt. So you can jump onto the ASIC website once you know the company's ACN, and you can make sure that there isn't a liquidator appointed or something else hasn't gone on that you're not sure about. So let's assume that you have got to the point where the company's not in liquidation, you're confident that there's enough money involved that it's worth your while. Then you need to decide, how will I go about trying to get this money paid? And this is, of course, assuming you've done your reminders and phone calls. So with all of these matters, the size of the debt matters. So in most states in Australia, there are tribunals that deal with small debts. And what's considered a small debt in each jurisdiction is different. But generally speaking, anything under about $25,000, there are expedited proceedings available to you that are basically a lawyer-free zone. So a tribunal is set up where you file relatively simple and straightforward documents explaining that you owed the money. The other side gets a chance to put their case. And then generally speaking, the tribunal will arrange some kind of mediation where someone from the tribunal sits in a room with you, listens to both sides, says, surely we can work this out. And then if you can, you end up documenting that and the matter's brought to an end. If you can't settle it, then it can actually go to a hearing. The tribunal can make an order and you can actually take that order and register it as a judgment. And then that's effectively the same as having had a full court case, and it allows you to do other things to enforce that judgment. And some of the other things include things like sending the bailiff out to sell off their property. It can include trying to wind up the company and have a liquidator appointed. And like I say, others often as well, having a judgment can result in that being reported with credit reporting agencies and it being a problem for the customer, because next time they want to borrow money, it'll show up on their record, and often that will be enough to prompt payment. However, you've always got to bear in mind with all of these things that you don't want to spend excessive amounts trying to recover something where either because it's disputed or because the customer has no money, you're not likely to ever see your cash. It's one of those really old sayings, but I know my parents certainly used to say, you can't get blood out of a stone. if you're owed money by a company that is quite literally on the verge of insolvency, then it may be that spending more and more money trying to recover it, it's just not economical. Now, I mentioned earlier that the NatRoad guide has got an example letter of demand. A letter of demand doesn't have to be exactly in the form that's in the guide, but basically this is where you reach the point that you tell your client that if they don't pay by a certain date, you're going to take it further and that you may bring legal proceedings. It's important to do this because if you have to bring legal proceedings and spend money, courts don't really like it if you haven't done everything that needs to be done beforehand, because they'll say, well, why are you here if you never actually told them that they absolutely had to pay by a certain date or you would bring the court proceedings. So it is important to give that final notice or that letter of demand before you launch into court proceedings. So as I said before, depending on the value of the debt, you may be able to bring proceedings yourself in those tribunals that I mentioned. And they have the benefit that they're quite informal, and generally speaking, lawyers are not allowed unless it's particularly complicated or both sides agree that lawyers can be part of those proceedings. They're also a no costs jurisdiction mostly. And what that means is if you lose, you don't have to pay the other side's costs because essentially they've got no lawyers anyway. So that's an advantage. As soon as you get involved in other court action, not the tribunals I mentioned, then there are court costs associated with those particular courts. And what that means is that theoretically, you can recover some of your legal costs from your customer. Now, it's important to stress that what I'm saying is some of those legal costs. The way the laws about legal costs work is that you will only get your costs back on a scale. And the scales are all really old. And so the amount that you, actually it's not so much that they're old. So the scales are basically set up so that it doesn't matter what an action is about, the most that you can recover, for example, for commencing proceedings is X. And it doesn't make any difference how much time a lawyer spent on it or how much they charged you, you can only get back $X. And so most of the time you will be lucky to get back 40 or 50% of what you spend. You've always got to bear that in mind when you're deciding, like I said, to go legal and use lawyers. So because court proceedings are unattractive from that point of view, they cost so much money, there are other things or other ways you might try and resolve proceedings. So what I'm talking about here is more where there's a dispute. So you say you owe me $25,000 for doing 13 trips from A to B. And they go, no, that wasn't what the deal was. The price was X. And by the way, we don't think we should have to pay for 3 of those trips because we think you took too long and you did a deal that you would get the goods there by Wednesday and they didn't get there till Friday. So we're not paying for those ones. So those kinds of disputed matters where it's not that the customer can't pay, it's that the customer won't pay and say they don't owe the money. Those kinds of disputes can often benefit from some kind of third party being involved and trying to get both sides to some middle ground. So I talked before about if you go to a tribunal, often this will be done by the tribunal itself, but there are various other bodies around the place that can help. So that you can have access to mediation through some state government bodies, or if the debt is big enough, you might even decide to get a private mediator, who's often a barrister. Both sides might agree to get someone like that involved and then sit down in a room with the mediator with both sides of the story. And then the mediator will often try and fashion a settlement between the two parties that everyone might not be absolutely happy with it, but it certainly ends the matter and it means that both sides feel heard and reach a solution. And mediation can also be very useful where you actually want to retain your relationship with the customer. So in other words, this is not necessarily the end of the road. This is a good customer where you've got yourself into a position where they don't want to pay for some reason, you want them to pay, but it would be great if you could reach a solution so that you could continue to work together in the future. I'm waiting for the time delay on this next slide. It's not happening, Rachel.
That's okay. Let me see if I can do it.
Yeah. You watch, it'll probably jump 3 slides in a row now.
Probably. Oh. Is that the slide we're meant to be on?
It is. So this is a slide that just goes into a little bit more detail about the sorts of mediations. So some mediations might actually be required under a contract you've got with your customer. I mean, those long contracts that you have with some big customers, they usually stay on a shelf or, filed away electronically somewhere until such time as something goes wrong. Nobody ever reads them. But quite often the contract itself will have some kind of dispute resolution provision in it that might say, for example, if there's a dispute between the parties and it can't be resolved, then it will be basically pushed up the chain to the CEO of both companies. And if then they can't sort it out, then it will go to mediation. And it might even say who pays for that mediation when it has to be arranged. I already mentioned those various pre-legal action mediation services that are offered through government. I mentioned the private mediation with a barrister. And you also need to be aware that if you get into a dispute between a principal contractor and an owner-driver in Victoria and Western Australia, there are also tribunals in those states that can deal with disputes. Okay, Rachel, I just pressed the button again. So if we give it a couple of seconds and it doesn't work, you might need to press it again.
Okay, I'm standing by. Sorry about this.
No, I don't know. It was working before.
Okay.
Okay, we'll skip this one because we've already talked about it.
Okay.
So this slide is essentially a summary. What we're saying here is there is no one size fits all when you're covering debts. It really depends each time on how much money is outstanding and what the circumstances are. Is the customer solvent? Are you confident that if you got a judgment, you would receive the money? Is the debt disputed to the point where you need a 3-day trial, or is there a bit of a dispute that you can resolve? Is it something you feel comfortable running in one of those tribunals for small debts that I mentioned? Once you get to the stage where it's a large debt and there's a big dispute, you probably do need to get some legal advice, even if the legal advice is just to make you get a feel for whether or not you've got a good chance of winning or not, because you don't want to start spending a lot of time and effort on something if the legal position for you is bad. Okay, next slide, Rachel. Another option for recovering debts is debt collectors. So you may be in a position where you can outsource that. So a debt collection agency might be able to basically, for a fee, take over recovering your debts, and they'll send the letters of demand and they'll ring up the debtor and they'll organise legal proceedings if the monies aren't paid. And those debt collection services can either be on a fee per letter or a fee per matter basis, or sometimes they're percentage based. If they recover the money for you, they get paid a certain amount. If they don't get paid. It really depends on the particular debt collection agency, and it also depends on how much work you're giving them, obviously. Debt purchasing is another option. So some debt collection services actually buy your debt or a whole portfolio of debts, but obviously then they're not going to pay you the exact amount that's outstanding. If you've got $100,000 owed to you and you say to them, well, look, I'm sick of collecting my own debts. How about you give me $100,000 and go do it for me? That's not likely to happen. You will lose something in the translation when you're doing that. Next slide. Phase 3. Okay, I'm going to go through this quite quickly from now on, because once you've decided what to do, basically all you've got to do is do it. So you need to be organised. You need to have all those documents we talked about in step 1 ready, so that you can convince a magistrate or you can convince a tribunal that the money's outstanding. If you do happen to reach an agreement with your customer that they will pay you back by installments, make sure you get it in writing. And as part of that, make sure they actually admit the debt, because what you don't want is to agree to get paid $200 a week for the next 6 months. Then they stop paying. And then they say, well, look, we never owed the debt anyway. We were just paying some bits and pieces, but we still dispute it. Always make sure you conduct yourself professionally. There's various guidelines issued by ASIC, basically saying, you can't harass people, so that, you, for example, you call them at midnight and tell them that they've got to pay, and then call them again at 1 a.m. and 2 a.m. And so effectively put unreasonable pressure on them. Always seek advice and assistance, and do look after yourself, because when you're owed a lot of money by someone and you're not being paid, and it's putting pressure on you financially as well, it can be very stressful. Next slide, Rachel. Phase 4 result. Hopefully the result is that you get paid, but even if you don't, or you get less than you're expecting, or you end up with an installment arrangement, think back to what we said at the beginning about trying to avoid this situation in the first place. Always make sure that you've got everything you need, your written agreements, your credit application, your evidence that you delivered particular items, preferably some conditions with a lien in that. And again, back to that first point, think about yourself as a banker, and don't let customers run up large amounts of credit in circumstances where it's an unsecured debt and you're not comfortable that they can repay. And don't leave it as well. All of the statistical evidence about debt collection is that once something is more than about 90 days old, your chances of not collecting that money increase exponentially. Next slide. And that is it. And we have time for questions if we have any there.
Wonderful. Yes, thank you, Gillian. We are now going to begin answering some questions submitted during the presentation. As a reminder to anyone watching, you can still submit questions in the Q&A box down the bottom. But Gillian, our first question is, how much does it cost generally to collect debt using a law firm? That might probably be a varying answer, but
it is very much a varying answer. But often law firms will, for example, issue letters of demand for a relatively small fee if you're doing a bunch of them. If you contact a lawyer once a year and say, here is a very complicated question where my customer won't pay, and here's 150 pages worth of the emails about why they won't pay, and can you please send a long letter of demand to them about this, then obviously that takes a fair bit of time to read through, etc. And you might end up paying for 2 or 3 hours of a lawyer's time to do that. On the other hand, if what you're doing is anytime something goes into 90 days, you're automatically sending it to a lawyer who puts something on their letterhead and sends it to the customer, then that's relatively cheap, because that lawyer can have a template for you where they basically fill in the name and address of the customer, the amount, attach the invoice and send it. And frankly, often lawyers sending letters of demand does get better results than sending it yourself, because it looks scarier. It looks like something might really happen. So there is a benefit from that point of view.
all right, well, that was our last question. Thank you, Gillian. Thank you, everyone, for attending today's webinar. If you do have any other questions that you would like to ask NatRoad or Gillian, you can email them to info@natroad.com.au. Today's webinar will be uploaded to our YouTube account and to our website, and the recording will also be sent to all attendees. So that should hopefully happen tomorrow. Once again, thank you for joining us today. Thank you, Gillian, and I hope everybody has a great rest of your day.
Thank you, everyone.